Good evening, all, and thank you for joining us today. My name is Akshay. I am the Project Director for Moneylife Foundation. Allow me to welcome you all for an important session today as we try to understand how the recently enacted Digital Personal Data Protection Act affects our right to information. For those of you who are joining us for the first time, Moneylife Foundation is a 13-year-old non-profit organization primarily engaged in spreading financial literacy and advocacy for savers. We also make efforts to spread consumer awareness on a variety of issues that are of interest to our members. Our right to information is one of the fundamental pillars in a democracy, which enables citizens to access information held by public authorities and also helps to foster transparency and accountability in the government. With the introduction of the Digital Personal Data Protection Act, there have been some concerns raised by activists and citizens alike. The Act has been criticized for several reasons as it neutralizes and even erodes our right to information. It deals a huge blow to the RTI Act by expanding the scope of personal information, potentially allowing public authorities to restrict access to certain information. So today, to discuss the implications of the Digital Personal Data Protection Act, we have the privilege of hosting two eminent personalities who have made significant contributions to the field of information access and transparency. Our first speaker, Mr. Shailesh Gandhi, is a trailblazer in the realm of right to information. As a former Central Information Commissioner, he has a remarkable legacy of his service, during which he has disposed of nearly 20,000 cases, setting a benchmark for efficiency and transparency. Mr. Gandhi's commitment to digitizing his office exemplifies his forward-thinking approach for transparency. Over the years, he has played a vital role in educating citizens and even public authorities about the Right to Information Act. Furthermore, his availability as an expert on our RTI Advice app has been invaluable to countless individuals seeking guidance in their pursuit for information. Our second speaker, Mr. Venkatesh Nayak, is an RTI activist and director at the Commonwealth Human Rights Initiative. He has been an unwavering advocate for transparency and access to information and has played a crucial role in advocating for the RTI Act in his early days. As the co-convener of the National Campaign for People's Right to Information since 2011, Mr. Nayak continues to be at the forefront of the important movement. His impact extends far beyond advocacy, as he has conducted extensive training programs for government officers across various states in India. He has also provided valuable assistance to governments and organizations in other countries, helping them develop and implement information access laws. We are very fortunate to have these distinguished speakers with us today to share insights and their expertise. I encourage all participants to actively engage in today's session. Together, we can deepen our understanding of this critical issue and perhaps works towards a more transparent and accountable society. Before proceeding further, allow me to share some ground rules for today's session. We have kept all of you on mute for the benefit of all involved and will only unmute you during the Q&A session. If you have any questions, you may use the raise hands button that is available on Zoom, but please keep your questions limited to a few minutes or even below 90 seconds, as we will not be able to take long questions. For optimal viewing, we suggest that you keep the webinar on speaker view. The meeting is also being recorded, and recording shall be uploaded to our YouTube channel, Moneylife TV, immediately after the video or after the event ends. Please feel free to use the chat section to share your comments, questions, and observations, but do send it only in the public forum, marking everyone. Please do not send us a private message, as we will not be able to monitor or reply while the session is live. Please also note that your cameras may be on by default, and you could be broadcasting your background and homes for everyone to see. If you wish to maintain your privacy, you may turn off your cameras now. And now, without taking much more time, I can request Mr. Gandhi to please take over and start his presentation. Over to you, sir.
Thank you very much, Akshay. Fellow citizens of India, we say India is the world's largest democracy. Democracy, the classical definition is rule of the people, for the people, by the people. So logically, if we own India, if we are the rulers of India individually, everything that is owned by the government is owned on behalf of us. All the information in the government is on behalf of the citizen. Therefore, logically, all information should be available to citizens to access. However, there are a few exemptions which are defined in the law and which are in line with the Constitution of India, which are permitted. Apart from this, there is nothing called confidential, nothing that cannot be shown to citizens. All information belongs to citizens and must be accessed by them, except the 10 exemptions of Section 8(1) of the RTI Act. And some one or two attempts were made to amend the Act, which were opposed. The last exemption was for determining the salaries and position of these information commissioners, which has been passed. But recently, without calling it an amendment to the RTI Act, a very dangerous exemption has been changed, which will have the effect of making RTI redundant, is my contention. And I'll share that with you. I'll share my presentation with you. In my view, it is possible to have a congruent view of Is my presentation visible, Akshay?
Not yet, sir. You'll have to share your screen.
Oh. Now is it visible?
Yes, sir.
My contention is that RTI Act, privacy and Supreme Court rulings until 2010 and the Constitution are in agreement with each other and are congruent. There is no real dispute between privacy and RTI, the way the law has been framed. And I will take you through this. Article 19 of the, just a minute. Protection of certain rights regarding freedom of speech, etc. This is a constitutional provision which gives us a fundamental right. All citizens shall have the right to freedom of speech and expression. This covers freedom to speak and express and to publish and get information. It's important to understand the freedom of media is not mentioned in the Constitution, but derives its rights, derives its authority from Article 19(1)(a). Supreme Court has held in various judgments that publishing information and speaking and expressing your information and right to information all fall under Article 19(1)(a). If this fundamental right has to be subject to any restriction, it has to be provided for in the Constitution. Article 19(2) of the Constitution provides for these restrictions. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. The only words that could relate to privacy, in my opinion, are decency or morality. Therefore, in the interest of decency or morality, some restrictions can be there which are linked to privacy. Section 7(1) of the RTI Act categorically states that the only reason for denial of information are given in sections 8 and 9. Section 9 covers copyright and intellectual rights, and section 8(1) has exactly 10 exemptions, the last of which is section 8(1)(j) relating to privacy. RTI Act section 8(1)(j) exempts information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the PIO is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to Parliament or a state legislature shall not be denied to any person. This is an important caveat, a proviso provided to Section 81J only. In the first draft of the bill, which was presented in December 2004, this proviso was put as a provision, Section 8.2. But in the final bill, this became a proviso only for Section 81J. This means, in simple English, information could be denied if it was personal information, but being personal information, it was not subject to denial. And disclosure had no relationship to public activity or interest, or it is unwarranted invasion of the privacy of the individual. However, this may be given if a larger public interest justifies such disclosure. Now, the conundrum comes because defining what is privacy. The Puttaswamy judgment, the 9-judge bench, declared that privacy is a fundamental right of citizens. Let's accept that as given. But the judgment, which runs over 500 pages, does not say what constitutes privacy. It has various theories, philosophies, talks of proportionality, but for an ordinary citizen or an ordinary officer, it is very difficult to understand what is privacy. The Puttaswamy judgment, in fact, says at 4 places that it cannot be defined and it will develop on a case-to-case basis. When framing the law, Parliament realized that the whole concept of privacy is slightly unknown and difficult to define. Therefore, they put this proviso only for Section 81J, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. How is this to be interpreted? Some people, some commissioners and judges have interpreted it correctly, saying that a subjective statement must be made that the person who is denying information under Section 81J would not give this information to Parliament or state legislature. And if it violates decency or morality, go back to Article 19.2, then certainly such information should not be given to Parliament or state legislature, and therefore it can be denied to any person. That is the logic of this section. Now, the Supreme Court before 2010, it's very interesting to note that before 2010 and after 2010, the Supreme Court's view of what constitutes a right to information and what can be denied and seems to undergo a great change. Privacy in Kharak Singh had said that it must encompass and protect the person's intimacies of the home, the family, marriage, motherhood, procreation, and childbearing. In Govind versus State of MP, Supreme Court said any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, motherhood, procreation, and childbearing. In R. Rajgopal, the clear ratio that emerges is a citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, amongst other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical.
So sorry to interrupt you.
Yes.
Can you put the slides in the full screen?
When I do that, 1 second. Okay.
Yeah, yes, sir.
Okay. Once a matter becomes a matter of public record, the right to privacy no longer subsists, and it becomes a legitimate subject for comment by press and media, amongst others. We are, however, of the opinion that in the interest of decency, Article 19, an exception must be made to this rule, which is a female who is the victim of sexual assault, kidnap, abduction, or a like offense should not further be subjected to the integrity of her name and the incident being publicized in press or media. Restrictions that apply to media would automatically apply to freedom of speech and automatically apply to right to information. In the case of public officials, it is obvious right to privacy, or for that matter, the remedy or damage of action for is simply not available with respect to their acts and conduct relevant to the discharge of their official duties. Please note this, because we are going to very soon talk of how this whole thing has been turned upside down. Section 4(1)(b) of the Right to Information Act expects that some of these details should be published suo motu. The monthly remuneration received by each of its officers and employees, including the system of compensation, is provided in its regulations. The budget allocated to each of its agency, indicating the particulars of all planned, proposed expenditures and reports on disbursement made. The manner of execution of subsidy programs, including the amount allocated and the details of beneficiaries of such programs. Particulars of recipients of concessions, permits, or authorizations granted. DOPT issued an office memorandum on 15 July 2013, saying that all transfer orders should be publicized through the website or in any other manner listed in Section 4(4) of the Act. Given this background, in the Girish Ramchandra Deshpande judgment, the Supreme Court held in a very peculiar manner. The Apex Court held that copies of all memos, show cause notices, and orders of censure, punishment, assets, income tax returns, details of gifts received, etc., by a public servant are personal information as defined in Clause J of Section 8(1) of the RTI Act and hence exempted and cannot be furnished under RTI. There's no reasoning given, nor the clause analyzed. The performance of an employee officer in an organization is primarily a matter between the employee and employer. And normally these aspects are governed by the service rules which fall under the expression personal information. The Supreme Court in its ruling, which I believe is not as per the Constitution or nor as per the RTI Act, said performance of an employee is primarily a matter between the employee and the employer. And who is the employer? The employer is the citizens of India. Do I have to tell the Supreme Court that the employer is a citizen of India and therefore must have access to information? And personal information by itself is not being exempted. But the Supreme Court laid this down. The details disclosed by a person in income tax returns are personal information which stand exempted from disclosure. No reasoning or explanation was given how the court came to this conclusion. And I want to show you another thing. The ADR PUCL case, by virtue of which those who stand for elections have to declare their assets, held that citizens have a right to know of the assets of those who want to become public servants. And in Girish Ramchandra Deshpande, the Supreme Court ruled that citizens do not have a right to know about the assets of those who are public servants. This, in my mind, is equivalent to saying that if a girl and boy want to get married, they must make disclosures of their lives to each other. But after they get married, the same kind of disclosures are not required, which I find really very difficult to understand. Section 8(1)(j, as said previously, exempts this, appears to have been read by the court as information related to personal information. It did not say whether it was a public activity or not, or whether it would cause unwarranted invasion of the privacy of the individual. And the proviso has just not been mentioned. It's as if it's forgotten by the Supreme Court. This, unfortunately, has become the standard for the Supreme Court rulings, and about 5 or 6 other rulings have upheld the Girish Ramchandra Deshpande judgment, which by saying that this judgment is okay, or has acknowledged this judgment and not made any critical remark about it. This has had a great impact on the right to information, but a lot of honest, law-abiding citizens and PIOs, government officials, and commissioners have been giving personal information without recourse to the Girish Ramchandra Deshpande judgment. Another way of looking at privacy I would like to pose before you. Does the government have the right to violate the individual citizen's privacy routinely? The obvious answer to my mind is no. Hence, most information which government takes in a routine manner must not be denied to citizens. Public records must be assumed to be not violating privacy. If the government's collecting the information routinely violates privacy, it should be opposed. The government seeks information about what happens in my house, what food I eat, etc. It should be opposed unless the government is paying the bill. One Supreme Court judge once asked me, he said, Mr. Gandhi, do you mean you can ask what I eat at home? I said, sir, RTI only covers what is on record. If what you eat at home is on record because the government pays for it, then I have a right to it. But if it is not on record, that does not even come in the realm of RTI. This has been reiterated by the R. Rajagopal judgment when it states, once a matter becomes a matter of public record, the right to privacy no longer subsists. In RTI, one can only seek what is on record. Hence, personal information collected routinely must be recognized as not violating privacy unless it violates decency or morality, in which case it should not be shared with Parliament as well. This is the clear logic of the law as it stands, which has been violated in many times. DOPT, even under the current law, DOPT refused total number of annual performance reports of IAS officers pending presently for 1 year, 2 years, 3 years, and 4 years, claiming an exemption to Section 81J. Their logic was, it is information relating to persons. Request for details of heavily funds was denied, saying it was personal information. Details of beneficiaries of PM fund refused. Amount spent on Amit Shah's security refused. Bogus caste certificate, education certificate, ghost employees, etc., refused. Disproportionate assets compared to declared income refused. Verification of affidavits of elected representatives refused. And the list goes on. But a lot of people were giving this information. Many were refusing information. And this was the situation, partly because of the Supreme Court's Girish Deshpande judgment. Section 44(3) of the Digital Personal Data Protection Act says, it talks of amending 81J thus, and exempts information which relates to personal information. What is given in red is completely knocked off. Therefore, all personal information can be refused as per the law proposed in the DPDP Act. Person in the DPDP Act is defined as natural person, HUF, company, state also. Personal, the word is not defined in any of the laws, but I would imagine it would automatically mean relating to a person. Definitely information relating to a natural person does fall in the personal information category. And this amendment to the law, in fact, acknowledges that so far decisions that were given based on it being only personal information are illegal. Whether given by courts, given by commissioners, given by PIOs, these were illegalities, and that is what it seeks to correct now. But this is a major thing. Most information can be linked to a person, and therefore it would become a right to deny information for the public information officer. DPDP Act and Section 38(2) talks of overriding all earlier laws, which would include right to information. And the violation of the DPDP bill, DPDP Act, can lead to penalties of up to 250 crore rupees. So forget 250 crores rupees. If a PIO is penalized 2 lakh rupees, he is not going to take the risk. No amendment to RTI Act should be made, and sign petition to PM at change.org save RTI Act. This needs to be opposed. This is a major problem for the RTI Act and for transparency. Supreme Court rulings until 2010 and Constitution are congruent. Exempting all personal information violates citizens' right to information beyond what Article 19(2) permits, and hence is unconstitutional. Section 38(2) and 44(3) constrict Article 19(1)(a) beyond what is permissible in the Constitution. And if today a right to information is constricted, tomorrow the same thing can apply to right to publish as well as to freedom of speech. You may be asked to give reasons why you should be allowed to speak or to publish something. Citizens must discuss this and ensure that their fundamental right is not constricted. This will also severely limit citizen action to curb corruption. One of the objectives of the RTI Act was to curb corruption. This will be severely restricted. If citizens do not defend their fundamental rights, they are failing in their duties as rulers of the democracy. Share this presentation with groups of citizens. All of us must make the effort to defend our fundamental right. Because this has been, in fact, I call it a right to deny information that is being slipped into the data protection bill. If they had talked of it as an independent exemption amendment to the RTI Act, there would have been great protests. But it's been slipped into the data protection where the elite feels that their privacy is safeguarded. Discuss this, ask for webinars across the nation, and oppose this is my submission. If you have a different view on privacy, let's contest it. Let's contest it in public space. Thank you very much. Thank you.
Mr. Venkatesh Nayak, I'll ask you to share your thoughts now.
Okay. I hope I am audible now.
Yes.
Thank you. So very good evening to all of you, ladies and gentlemen. I would like to thank Moneylife Foundation for inviting me to share my thoughts on this subject matter of today's discussion. Ideally speaking, there is very little that I could hope to add on the core subject matter after Shailesh ji's presentation. It's been quite comprehensive and elaborate. However, since I've been invited, I have to do my job. So I would like to share a few thoughts with you, going a little deeper into the whole idea of rights, right to information, right to privacy, and what could possibly happen if the government, and of course it will, there's no question of if there, but when the government implements the Digital Data Protection, Digital Personal Data Protection Act, as we call it, DPDP Act. Pardon me, most of my life I have spent in northern India studying and then working. So I have a tendency to slip into a bilingual speech. And I find that quite effective. I'm assuming that most of the participants here do understand Hindi. So pardon me if I move between the two languages. If you find it difficult, do let me know and I'll just stick to English. That's possible. Because sometimes expressing in a language that one is more familiar with, particularly because one is born and brought up in that milieu where that language is spoken, that helps express one's thoughts a lot more candidly and a lot more effectively than one would want to do or one would hope to do in English. So let me start with a little bit of Hindi. आम तौर पे ये एक आदत है हम लोगों की, मैंने भी किया है. कभी भी एक छोटे बच्चे से हम मिलते हैं उनके माँ बाप के साथ कहीं सैर करते समय या फिर किसी शॉपिंग दुकान पे, आजकल तो मॉल जाते हैं बच्चे, और बच्चे अगर हमें भाग गया, चाहे लड़का हो या लड़की हो, आमतौर पे सवाल पूछा जाता है बच्चे से कि आपको मम्मी ज्यादा पसंद है या पापा ज्यादा पसंद है. और बच्चा बिल्कुल अचंभे में जवाब दूं, माता पिता दोनों साथ हैं. माँ बोलूंगा तो पिता को बुरा लगेगा, पापा बोलूंगा तो माँ को बुरा लगेगा, मम्मी को बुरा लगेगा, तो क्या बोलूं. कुछ बच्चे फिर भी बहुत फ्रैंकली हो कि अपना चॉइस बता देते हैं. कुछ बच्चे उम्र के हिसाब से बहुत डिप्लोमेटिक होते हैं, बोलते हैं नहीं 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 मुझे दोनों पसंद है. और कुछ बच्चे, जैसे हमारा तजुर्बा है सरकारों की चुप्पी को सुनने का. किसी संगीन मुद्दे पर, किसी कंट्रोवर्सी के ऊपर सरकार कुछ बोलता ही नहीं है. जैसे हम लोग सब उम्मीद करके बैठे थे कि मणिपुर में जो कांड हो रहा है, जो आग लगी है, उसके ऊपर हमारे देश के प्रधानमंत्री जी, आदरणीय प्रधानमंत्री जी कुछ विस्तृत रूप से बोलेंगे. उम्मीद पे पानी फिर गया. कुछ तो बोले वो, लेकिन हम लोगों की नहीं, तो ये बहुत इस प्रकार चुप्पी साध देते हैं, बोलते नहीं है। मामा ज्यादा पसंद है या पापा ज्यादा पसंद है। तो what is happening today with all of us as citizens is we are being asked, and in fact we are being forced to say that right to information is less important than right to privacy. And as a counter to that, some of us are saying that no, right to information is more important than right to privacy. यहाँ पर कोई पसंद की बात नहीं है जो हमारे सोच के मुताबिक जवाब हम दे रहे, एंड दैट इज मोस्ट अनफॉर्चुनेट। और ये क्यों है वो मैं इसलिए बोल रहा हूं, जैसे शैलेश जी ने बताया, राइट टू इंफॉर्मेशन, जानकारी का अधिकार, और राइट टू प्राइवेसी, एकांतता या निजता का अधिकार, दोनों फंडामेंटल राइट्स हैं। बोथ आर फंडामेंटल राइट्स, और दोनों का जिक्र आपको कॉन्स्टिट्यूशन में नहीं मिलेगा। तो कॉन्स्टिट्यूशन को जो लोग पढ़ते नहीं है वो पूछते हैं कि कॉन्स्टिट्यूशन में कहाँ लिखा है, आपने कहा कौन से एंगल से बोल कि ये फंडामेंटल राइट है। नहीं, फंडामेंटल राइट तो बन गया नहीं, वो कैसे मैं थोड़ा बताऊंगा संक्षिप्त में, बट थोड़ा सा क्योंकि मैं हिस्ट्री का स्टूडेंट रह चुका हूँ, इस बात को मैं काउंटर करना चाहता हूँ जो काफी फैला हुआ है, जो आरटीआई के सपोर्टर्स बहुत हैं हमारे देश में, मैं भी हूँ उनमें से एक। लेकिन हम में से कुछ लोग ऐसे सोचते हैं कि हमारे देश में प्राइवेसी के लिए इतना महत्व नहीं दिया था। वी डिडंट रियली प्लेस मच एम्फेसिस ऑन प्राइवेसी एज अ कल्चर in different parts of the country. And one of the indicators that the critics of right to privacy give is, they say, look at our languages, be it Hindi, Kannada, Gujarati, Bangla, or any other language that is widely spoken in the subcontinent of India. They say we do not have an equivalent term for privacy, which I find very surprising. Yes, there is no term that encapsulates the multi-dimensional content of the term privacy. It's not there. It's not there in Kannada. We find it difficult. It's not there in Hindi. I can safely say that in most of the other languages also, there isn't a word that encapsulates it. But that's the nature of languages. What you say and mean by the word sensibility in English is quite different from its synonym in French, where they say mentalité. Mentalité is not the same as mentality in India, so in English. So we shouldn't be quibbing over the presence or absence of words that describe a particular concept or notion or idea. And it is definitely unfair to any culture or to any country to say that you did not have a concept of privacy. Let me just give two examples. Since I'm a student of history, I go back to history to give some examples about the right to privacy. Just two, and both of them are from the Mahabharata. Maybe three, we can say. Three from the Mahabharata. The first one. All of you are aware of the curse which King Pandu invites upon himself. So when they are in Vanvas, Pandu, Madhuri, and Kunti, there is a curse that is placed on him. What happens is when Pandu goes hunting, he chances upon two deer. ये जो हिरन होते हैं, the two deer are copulating. And mistakenly, thinking that it is an animal, Pandu shoots an arrow and injures fatally the male deer. And because it is a mythology with multi levels of meaning and ideas to convey, suddenly the male deer transforms into a very beautiful rishi. I forget the name now, because too much of RTI and constitution-related work in the last 2.5 decades have made me forget quite a bit of my history, which I studied up to my PhD level. So he curses Pandu and says that you have interrupted and caused us problems when we are in the middle of one of the most sacred of acts of human society. And they were not out there in the open. They were there somewhere, they were in their act, somewhere in the middle of the bushes in the forest. So it is not like it was publicly, it was like a public spectacle that they were facing, that they were going through. So a curse is placed. Now, there may not have been a use of a term privacy, but what exactly does this episode indicate? That howsoever powerful or howsoever sharp shooter a hunter might be, he or she does not have any business shooting arrows at animals which are copulating, let alone human beings. This is one instance where privacy, without being talked about in the terminology of privacy, actually highlights the importance of privacy. Then let's take the second Upakatha. This is the main Katha from the Mahabharata, the second Upakatha. Many of you are aware of the story of Pururavas and Urvashi. Pururavas is one of the ancestors of Lord Rama. He's from that solar lineage. So Pururavas, and that Pururavas legend is from the Rig Veda itself. So Rig Veda में कुछ और वहाँ पे उसका portrayal होता है, महाभारत आते आते कुछ और होता है, पुराणों में कुछ और होता है. Anyway, they're telling me audio is not clear, so let me try and switch off my video, so then maybe my audio might come out clearly. Is that okay, Akshay? Otherwise, you'll only be able to see me but not hear me. What
Yes,
do you
sir.
think?
Yes, sir. Yes,
Okay.
sir. That's fine.
I'm so sorry. Maybe after a few minutes, I'll restart my video. So Pururavas is chasing Urvashi, the Apsara, and finally, after a lot of chasing, the way we say, the way we see in our Hindi movies, so the Mahabharata also has that story. So after a lot of courtship, Urvashi finally agrees to be with Pururavas and says, yes, I'll be with you, but only on two conditions. Condition number one, when the two of us are together in intimacy, it should always be in the dark. You should never see me when I'm naked. And the second thing is, she says, I've got two goats and you have to protect those two goats. And if those goats escape from our house, then I will leave you. So on that condition, thank you. On that condition, Pururavas and Urvashi start living together. And obviously, Urvashi is an Apsara. And Lord Indra, who has a claim over all Apsaras, gets very worried. She doesn't come back for a month, a year, 2 years. Isko wapas kaise le aaya jaye? And they hatch a plot. So what they do is, they get hold of one of the minor devas to go to the goat shed and release the two goats. So then what happens? The goats are released and they start bleating. And when they start bleating, Urvashi hears that she's in bed with Pururavas. And she tells Pururavas, hey, somebody seems to might be stealing our goats. Go and protect them. So obviously Pururavas wants to keep Urvashi with him. So he will do everything that she tells him to do. So he wakes up. He gets up from the bed. And by the time he is off the bed, Indra causes a lightning flash to happen. And in the lightning flash, totally innocently and without realizing it, he actually happens to see the bare body of Urvashi. And the goats are stolen away. So both conditions are lost, are broken. And therefore Urvashi says, sorry, I have no choice. You have not been able to honor the two conditions that I laid down. So I have no choice but to go back to heaven. And she goes away. Then there's a long story as to how they reunite. We don't need to go into that. But what does this indicate? It is a mythological way of expressing the importance of privacy, even though they may not have used a terminology. And the third and the last instance that I want to talk to you about is again from the Mahabharata, the arrangement that the Pandavas, the 5 brothers, had in terms of cohabiting with Draupadi, who's their wife. So at the time of marriage, when Kunti says, share Draupadi amongst the 5 of you, thinking that it was some food that they had brought during their vanvas. So they have to come to an arrangement. There are 5 claimants, all legitimate, 5 husbands to Draupadi. So who's going to be with her when and for how long. So they have a rule laid down. It says that Draupadi will spend an entire year with each brother, and in strictly the order of seniority. So first with Yudhishthira and last with Sahadeva. And they have a penalty that is decided as part of the rule, that if the rule of privacy is broken, and what is the privacy? That when Draupadi is with one husband, the others have absolutely no entry into the Antapura where the husband and Draupadi are together for that period. And if that rule is broken, then the person who breaks the rule has to go away for an entire year into another vanvas. And that's what happens. In order to make sure that these brothers are split up, the Kauravas hatch a plot, and they attack the cows, which are supposed to be feeding this, family. And in order to protect them, Arjuna rushes into the house and he realizes that his weapons are in the bedchamber where Yudhishthira and Draupadi are together. But for that moment, he realizes that protecting the cows is more important. He breaks the rule and he takes his weapons without looking at them and goes away to protect the cows which are under attack. And after the attack is foiled, the brothers come back together and they agree that yes, Arjuna has broken the rule of privacy. So he has to go away for vanvas for 1 year. And that leads to his meeting Lord Shiva to acquire the divine weapons. Now that is part of the mythology. But what is the central principle that underlines the story? That there is a right to privacy. So when people tell me there can be n number of stories, you look up our Puranas, you look up further texts, Sanskrit or local language texts, Gujarati, Kannada or Tamil. Examples of privacy are all lying there. So to tell us that privacy is not part of our culture, it doesn't have to be given the same level of importance which European cultures or American, North American, societies give, is a bit difficult to digest. Having said that, now after this whole storytelling, let me get directly into the legal parts of it. And now let me share my presentation with you. Why do I say that the right to privacy and right to information are equally important? And now I'm going to share my screen. I hope I can make it full screen now. So let us start with the understanding of the right to privacy. Very often, the right to privacy is understood as a negative right. Now, why is that so? It's not a negative right for the person who is supposed to have the privacy. It's actually a negative obligation on the state from interfering unreasonably and unnecessarily with the privacy of an individual. That is a traditional understanding. If you go back to look at the jurisprudence regarding the development of the concept of right to privacy from the 17th century or so, or even the 16th century for that matter, from the United Kingdom, you don't need to do extensive research. State of Union of India, उस जजमेंट 9 जज कॉन्स्टिट्यूशन बेंच में उस जजमेंट का वो 500 पन्ने का जिक्र जो शैलेश जी ने किया था, उसको आप पढ़ेंगे तो राइट टू प्राइवेसी का उगम और उसका एवोल्यूशन, इसके बारे में आपको एक अच्छा खासा कमेंटरी मिल जाएगा उस जजमेंट में. तो उसको अगर आप देखेंगे तो you will realize that the right to privacy actually originates as a common law right. मतलब किसी कॉन्स्टिट्यूशन में नहीं लिखा था, किसी लॉ में नहीं लिखा था, लेकिन कोर्ट्स के द्वारा, जजेस के द्वारा इस राइट को रिकॉग्नाइज किया गया था इंसाफ को दिलाने वाले संदर्भों में, यानी अलग अलग मुकदमों में. ज्यादा डिटेल में जाऊंगा नहीं. उन मुकदमों के आधार पर जो राइट टू प्राइवेसी का उगम हुआ, उसका डिस्कवरी हुआ, उससे कुछ बुनियादी बातें हैं. जैसे स्टेट हैज नो राइट टू इंटरफियर into an individual's personal matters, a person's thoughts, correspondence, telephone conversations, their family matters, or even enter the home, the dwelling of the person. without good cause. And when I say good cause, what I mean is defensible and legitimate cause permitted by law. So these were how, so this is how the right to privacy originates. And its basis, क्योंकि ये कानून में नहीं लिखा है, किसी संविधान में नहीं लिखा था उस जमाने में, तो उसका origin is from the right to personal liberty and the right to personal property. So the right to privacy originates from these two rights. But until about the mid-1980s, the personal information wala dimension of right to privacy has not received much recognition internationally. So the protection for personal information as part of the protection of a person's right to privacy, it originates in the mid-1980s, around 1983, in a German constitutional case, which is quite similar, not totally similar, but quite similar to our Aadhaar wala phenomenon. In the 1980s, the German government makes a law saying that we want to count our people, population census karna hai, and we will do it electronically. And we will assign everybody a number. So database banana hai. Now that is challenged, that law is challenged before the German Constitutional Court to say that, look, you cannot make human beings, individuals, particularly citizens, synonymous with numbers. They cannot be impersonalized, and therefore human beings cannot be databased at random or at will of the state. There has to be certain kinds of protection. If information about people has to be collected, people have to be told why. People have to be told what purpose will that information be used for. People have to be told for how long will that information be kept. People will have to be told when is that information likely to be destroyed, after the use or utility value is over. People should also have the right to know what information about them the government is holding, and if they find that the information about themselves that the government holds contains any errors, then they have a right to get it corrected. और इंटरनेट के जमाने के आने के बाद जब इतना सारा हमारे बारे में इंफॉर्मेशन हम खुद इंटरनेट पे डालते हैं, फेसबुक पे डालते हैं, इंस्टाग्राम में डालते हैं, लिंक्डइन में डालते हैं, अलग अलग जगह डालते हैं, सोशल मीडिया, यहाँ वहाँ फलाना ढिमकाना, then there is also something that is called the right to be forgotten. एक बार हमने अगर जानकारी अपने बारे में वेबसाइट पे डाल दिया या किसी और ने हमारे बारे में डाल दिया, कुछ समय बाद अगर हमें लगता है कि इस डेटा को इरेज करना है तो वो इरेज होना जरूरी है, वो भी एक राइट हो जाता है. So all of these are part of the growing facets of the right to privacy. So right to privacy is no longer just about protection for one's liberty and property. It's also about protecting information about oneself. So the right to informational privacy arises from the foundation which is called a citizen's right to determine how much and in what manner information about oneself can be collected, used, and later on discarded when not required. So these are all the dimensions of the right to privacy. Now let's move on. So the right to privacy is recognized in the Universal Declaration of Human Rights. India is a signatory to this document, which was finalized in 1948. December 10 तारीख को इसका सालगिरह होता है. So at that point of time, informational privacy was not so much of a recognized facet of the right to privacy, but the right to personal reputation was definitely part of it. And the state was barred from interfering in the right to privacy of any individual in an arbitrary manner. And later on in 1966, the right to privacy is included in a binding international human rights covenant called the International Covenant on Civil and Political Rights, where again the right to privacy is recognized as a basic human right. India ratified or acceded to this international covenant in 1979. So we are duty bound to ensure promotion, protection, and fulfillment of every individual's right to privacy in India. The government has a duty to do this. Now let's move on. If you look at the Protection of Human Rights Act of 1993, which is the basis for the establishment of the National Human Rights Commission Maharashtra State Human Rights Commission, and several other state human rights commissions, and also human rights courts at the district level in several states. Probably there are about 15 or 16 states now which have district level human rights courts. So the Protection of Human Rights Act forms the basis. It is a parent law for these mechanisms. So in this parent law, the rights, including right to privacy, recognized in the International Covenant of Civil and Political Rights, it receives statutory recognition in India. Earlier, it was a recognition of as part of international human rights law. Now it is recognized as part of our domestic law. अपने देश का कानून का हिस्सा भी right to privacy बन जाता है. और 2016 में, जैसे शैलेश जी ने बताया, 9-judge bench of the Supreme Court of India recognized the right to privacy as a deemed fundamental right under Article 21. लेकिन उन्होंने ये भी बोला कि right to privacy का वास्ता केवल आर्टिकल 21 से ही नहीं, लेकिन आर्टिकल 19 में जो अलग अलग फ्रीडम्स दिए गए हैं, लाइक फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, फ्रीडम ऑफ ट्रेड एंड प्रोफेशन, फ्रीडम टू फॉर्म एसोसिएशंस, फ्रीडम टू फॉर्म यूनियंस, फ्रीडम ऑफ असेंबली, एक जगह पे एकत्रित होना, फ्रीडम टू मूव अबाउट द टेरिटरी ऑफ इंडिया, और उसके अलावा जो हमारा फ्रीडम ऑफ थॉट एंड कॉन्शियंस एंड द राइट टू होल्ड रिलीजियस बिलीफ्स, आर्टिकल 25 में, इन सभी फंडामेंटल राइट्स का right to privacy जो है एक हिस्सा बन जाता है. So that is how they interpreted the right to privacy. Now there are people who are worried about this kind of a interpretation because they say that look, then you end up making the right to privacy into something called a super fundamental right. क्योंकि इतने सारे fundamental rights का हिस्सा अगर right to privacy बन जाता है तो इसका ओहदा बिल्कुल बाकी rights के मुकाबले बढ़ गया. Lekin thankfully the Supreme Court says ultimately it is to be located in Article 21 of the Constitution. लेकिन इस 2016 के जजमेंट के आने से पहले हमारे देश के बहुत सारे कानून जो हैं वो प्राइवेसी को वैसे भी लीगैलिटी प्रोवाइड करते हैं, जैसे एविडेंस एक्ट 1872, द इंफॉर्मेशन शेयर्ड बिटवीन स्पाउसेस, ऑर्डिनरीली इट कैन नॉट बी कंपेल्ड टू बी प्रोड्यूस्ड इन अ कोर्ट ऑफ लॉ unless it is absolutely required in a criminal trial or in a matrimonial dispute, and there are certain safeguards for how this information will be made available. Income tax returns ka privacy is protected under Income Tax Act 1961, although there is also a clause which says in the larger public interest even income tax returns of SSCs and any other information that the income tax department may have can be disclosed. अब हमारा 21st century economy का ये एक बड़ा सा योगदान बन गया है इकोनॉमी के लिए, और वो ये है कि जो लोगों को ज्यादा से ज्यादा कर्जा लेकर जीवन जीने के लिए मजबूर करो, इसके लिए लोन लो, उसके लिए लोन लो, और आप अगर लोन नहीं लेते हैं तो आपका क्रेडिट रेटिंग बिल्कुल कम रहेगा या होगा ही ना के बराबर रहेगा. तो इसलिए लोन लेना जरूरी है, क्योंकि अगली बार जरूरत पड़ने पर अगर आपको लोन लेना पड़े आपका क्रेडिट रेटिंग देखते हैं. तो ऐसे स्थिति में क्रेडिट इंफॉर्मेशन कंपनीज रेगुलेशन एक्ट में भी जो लोगों का क्रेडिट रिलेटेड इंफॉर्मेशन है काफी हद तक इसको प्रोटेक्शन मिला है अंडर द गार्ब ऑफ प्राइवेसी. शेयरिंग भी होता है विद लॉ एनफोर्समेंट एजेंसीज एंड बिटवीन दीज क्रेडिट इंफॉर्मेशन कंपनीज. वी डोंट नीड टू गो इनटू दोस डिटेल्स. आई एम प्रीटी श्योर दैट दोज ऑफ यू who are with Moneylife Foundation or those of you who are participants who are experts in economy and commercial matters, you will recognize this even better than I do, or even banking experts will know this better. उसके अलावा कलेक्शन ऑफ स्टैटिस्टिक्स एक्ट ऑफ 2008, जहां पर सेंसस के माध्यम से या सर्वे के माध्यम से सरकारी महकमे लोगों के बारे में व्यक्तिगत जानकारी एकत्रित करते हैं, उनके लिए भी प्राइवेसी का प्रोटेक्शन मिला है. नॉट इन दोज वर्ड्स बट information about an individual contained in the survey schedules cannot be accessed even under the Right to Information Act. मोटा मोटी तौर पर स्टैटिस्टिक्स जहां पर किसी इंडिविजुअल का पहचान नहीं होगा वो डेटा ले सकते हैं, बट एक स्पेसिफिक इंडिविजुअल ने एक सेंसस सर्वे में क्या जवाब दिया या किसी और तरह के फैमिली हेल्थ सर्वे में क्या जवाब दिया, क्या डेटा दिया, इंडिविजुअल लेवल पे आप उसको ले नहीं सकते. द लॉ बार्स एक्सेस. फिर इंफॉर्मेशन टेक्नोलॉजी एक्ट इज देयर और IT रूल्स हैं, दे ऑल्सो प्रोटेक्ट इलेक्ट्रॉनिक प्राइवेसी पर्टिकुलरली इन अ बिग वे. और अभी तो DPDP एक्ट भी आ गया है. सो व्हेन आई मेड दिस प्रेजेंटेशन, दिस वाज इन 2015, तो उस वक्त 2012 का एक कमिटी बना था, ग्रुप ऑफ एक्सपर्ट्स हेडेड बाय जस्टिस JP शाह. तो दे लुक्ड एट द इश्यू ऑफ राइट टू प्राइवेसी एंड पर्टिकुलरली राइट टू डेटा प्रोटेक्शन, एंड दे केम अप विद सम रिकमेंडेशंस व्हिच वी विल टॉक अबाउट अ लिटिल लेटर. Now we come to right to information. आप सबको पता है जो RTI के बारे में जानकारी रखते हैं कि right to information is also a deemed fundamental right. Constitution में आपको वो पढ़ने के लिए नहीं मिलेगा, लेकिन सुप्रीम कोर्ट के कई सारे जजमेंट्स के मुताबिक it is part of Article 19(1)(a), which is the right to freedom of speech and expression. The right to know is part of right to freedom of speech and expression. But very few people are aware, including lawyers, that people's right to know is also part of Article 21, which guarantees right to life and liberty for every individual and not just citizens. Article 19(1)(a) protects the right to freedom of speech and expression and therefore the right to know of only citizens. But Article 21, which is about right to life and liberty, is available for non-citizens also, who come under India's jurisdiction for any reason. And the right to know, which is part of Article 21, is available for non-citizens as well, any individuals. दो cases है, एक 1988 का है, एक 2004 का है. So then comes this question, that if the right to privacy and the right to information are A, both fundamental rights, and B, are part of the same fundamental right called Article 21, then how can a law be passed which says that right to privacy, personal data protection, is more important than the right to information? That is where the problem arises, because it goes completely against well-established case law about how to balance various fundamental rights that are listed in Part 3 of the Constitution. But we don't need to go into that right now. Let me further move on. Let me stop sharing my screen here and very briefly, I know I've taken a lot of your time, so let me very briefly share a few thoughts about what would be the impact of the amendment made or proposed through the right to information, to the right to privacy, through the DPDP Act. RTI का जो amendment हुआ है उसका असर क्या हो सकता है ये मैं बताऊंगा. क्या हो सकता है इस बात पर ध्यान दीजिएगा. I am not saying क्या हो गया, क्या हो सकता है. The reason I am saying is, and this is again very few lawyers will be able to tell you because they don't pay so much attention to these matters. Today, the Digital Personal Data Protection Act, DPDP Act, has been duly passed by both houses of parliament, and Honorable President of India has given her assent to it, and it has been published in the Gazette of India. For all practical purposes, it has become a formally enacted law, but it is not yet in force. Section 1, subsection 2 of the DPDP Act says very clearly that the government reserves to itself the power to bring into force either the entire law in one go, DPDP Act, or its various parts at different points of time. And a good example of this is how the Right to Information Act was implemented. The law was passed in the middle of May by both houses of parliament. 12 तारीख 2005 मई को पार्लियामेंट ने अपनी रजामंदी दे दी, और जून 15 को महामहिम राष्ट्रपति जी ने अपना हस्ताक्षर उस कानून पे कर दिया, और 21 जून को वो गेजेट में पब्लिश भी हो गया. So right to information, some of the provisions became operational immediately, but the request relating provision, the appeals relating provision, they became operational only 120 days later. That is on the 12th of October 2005. So that is something that needs to be understood. With the DPDP Act also, yes, it is a legitimately and formally passed law, procedurally speaking. I am not talking about the legitimacy as far as the various aspects of that law is concerned. People will challenge it in court later on, including the amendment to RTI. वो हम उसमें जाएंगे नहीं. But it is a law that has been lawfully passed, but it is not yet enforced. Therefore, today, if you file an RTI application seeking personal information, particularly let us say about public servants, किसी का asset disclosure, या फिर किसी के travel in relation, expenses in relation to official work, if the PIO says that I will not give it to you because now 81J is, as amended by the DPDP Act, is applicable, therefore it is personal information, I can't give it to you, that will be a wrong decision. Why? Because DPDP Act has not yet become operational. So 81J will still have to be invoked in the original manner the way it stands. Yani, it is personal information, but disclosure will be barred only if there is unwarranted invasion of the privacy of an individual, or there is no public interest or public activity in disclosing that information. So if you come across responses where they invoke the amended form of 81J, immediately go and challenge it until the government enforces that amendment to the RTI Act. The next part that I want to tell you, and this is where I very humbly beg to disagree with Shailesh ji, and he knows about this. 81J का जब amendment किया DPDP Act के through, 81 के नीचे एक जो proviso था कि information that cannot be denied to Parliament or state legislature shall not be denied to any person. इस proviso को भी उन्होंने उड़ा दिया. So when the DPDP Act and this amendment is made operational, वो proviso भी रहेगा नहीं. आज की तारीख में वो proviso है. क्यों? क्योंकि amendment operationalize नहीं हुआ है. तो हम में से कुछ लोग हैं, this is another school of thought. One school of thought is what? Shailesh ji, with very good reason, says that proviso is applicable only to 81J. But I belong to another school of thought where we say that no, that proviso कि पार्लियामेंट को और लेजिस्लेचर को जो आप डिनाई नहीं कर सकते, जानकारी नागरिक को डिनाई नहीं कर सकते, वो एक बुनियादी सिद्धांत है. और वो प्रोवाइजो, वो परंतु applies to all 10 exemptions under section 81. क्यों? सिंपल सा लॉजिक है. जिस उस बात से जो शैलेश जी ने अपना प्रस्तुतिकरण शुरू किया कि हाउ डू वी डिफाइन अ डेमोक्रेसी, इट्स अ गवर्नमेंट ऑफ द पीपल, बाय द पीपल, फॉर द पीपल. So the information that government holds or collects or accumulates in the course of everyday work, that is not government property, that is public property, but government is the custodian. So they have to ensure that if public interest demands disclosure, information will have to be disclosed, personal information. But if public interest is likely to be harmed, then that information will not be disclosed. So in that context, if we as citizens elect MPs, MLAs, and indirectly we elect MLCs, and they have a right to demand information on the floor of the house by raising questions, then we as the people who elect them should also have the same right to information. So in our view, in our school of thought, that many of us believe that this proviso, that information that cannot be denied to Parliament or cannot be denied to state legislature should not be denied to any citizen, it reflects that basic foundational principle of a democracy. We, the citizens, are principals. People in government, whether they are MPs, MLAs, MLCs, or whether they are officials, they are all our agents who are working on our behalf. So they are the custodians of the information. So if MP, MLA, MLC can ask information on the floor of the house, we also have the right to ask similar kinds of information through RTI law. So when you remove that proviso, also what happens is a guiding principle, which is foundational to democracy, is taken away. Which was explicitly mentioned in the RTI Act, is now taken away. So this will lead to greater and greater litigation. So this is one part of the problem as far as the impact of the amendment is concerned. Another part of the problem is कि सेक्शन 4(1)(b) के तहत बहुत सारी जानकारी लोगों के बारे में पब्लिक करना जरूरी है. जैसे डायरेक्ट बेनिफिट ट्रांसफर स्कीम्स के बारे में जो बेनिफिशियरीज हैं, उनका नाम, किसको कितना मिला के तहत, नेशनल सोशल असिस्टेंस प्रोग्राम के तहत पेंशन्स या स्कॉलरशिप्स, गन लाइसेंसेस, होटल लाइसेंसेस, सिनेमा घर चलाने का लाइसेंस, इन सारी चीजों के बारे में जानकारी पब्लिक करना जरूरी है. खुद ब खुद proactive disclosure. Our worry is once these amendments to the RTI Act, section 81J, जब बोलते हैं कि पर्सनल इंफॉर्मेशन बिल्कुल देंगे ही नहीं, कोई दायित्व नहीं है हमारा देने का. So all of this information is necessary for ensuring that public money goes into the hands of people who are eligible for those schemes and not into the hands of ineligible people. वो verification करने का जो बुनियाद है, जो basis है, वो database ही गायब हो जा सकता है. So this is another cause for concern. Corruption could be rampant. Another thing, today MPs, MLAs, and people who contest elections to parliament and state legislatures अपने asset declaration करते हैं, liability declaration करते हैं. Our worry is all of that might become personal information according to the amendment. And DPDP Act के तहत वो सारा हटाया जा सकता है. So how do you prove that an MP or MLA has made money 10 times more than what they declared 5 years ago, or 30 times more than what they declared 10 years ago. Association for Democratic Reforms is regularly analyzing these income disclosure, these asset disclosure affidavits of candidates and serving legislators and parliamentarians. And they are showing how much richer they have become from the time when they disclose their assets publicly. वो सारी जानकारी गायब हो सकती है. Another part of the problem also is corruption. How do we prove, or how do we even get a complaint filed against an officer who is known to be corrupt, to show that that person has accumulated assets beyond the known sources of income, if their property returns are also taken away from the public domain? And finally, something even more basic: voter lists, or what we call electoral rolls. They are today public. Despite the fact that they are public, we know that there are lots of bogus entries, which leads to bogus voting. We also know that lots of people are legitimate voters are taken off that list under one pretext or the other, and they are denied what is called disenfranchising. ये भी हो रहा है. कल को privacy के आधार पे, data protection के आधार पे अगर electoral rolls को भी इन्होंने गायब कर दिया और बोला कि only voter will be able to see his or her details in the electoral rolls, third party cannot see, then how do you prove that the electoral rolls are fudged? So there are several problems. That is the reason why it is important that we have these kinds of discussions and debates to determine what should be the extent to privacy protection given in our country. It does not need to be influenced by actions taken in Europe. वहाँ पे global data protection regulations है, very high standards of personal data protection. क्या वो हमारे लिए जरूरी है? To give you an example, tomorrow, if you were to upload this recording on a public platform like YouTube or your own website, I could actually, if I'm covered by the GDPR regulations, I could say, how are you publishing my speech, my thopada, and my details and my stories without taking my consent? Public debate ही खत्म हो जाएगा फिर तो. या फिर पूरा पेपर वर्क बनाओ, फॉर्म बैठ के फिल करो, कंसेंट फॉर्म डिस्क्लोज करना है कि नहीं करना है. यहां तक कि टुडे इफ यू एक्चुअली लुक अप द जजमेंट्स दैट कम आउट ऑफ द कोर्ट्स इन द यूनाइटेड किंगडम एंड इन यूरोप, हु इज द पिटिशनर, हु इज द रेस्पोंडेंट, आपको पता नहीं चलेगा. नाम ही हटा दिया उन्होंने. दैट इज द एक्सटेंट टू द एक्सटेंट ऑफ द राइट टू पर्सनल डेटा प्रोटेक्शन दैट दे हैव as standards in their country. Do we want that in our country? We have to decide. They can't decide. And my last point is this: if you very clearly look and deeply probe the DPDP bill, the statement of objects and reasons attached to this bill when it was tabled in Parliament, you will realize that this is the bill that is being brought in under the pretext of protecting personal privacy, but the actual intentions are to benefit the commercial sector, the business sector in a big way, to play around and trade around with people's personal information, while letting the government go scot-free in terms of the information that it collects about us, what we call surveillance or even mass surveillance, under the justification that we need to collect this information and we will not tell you what we have collected, we will not let you see it because we need it for law enforcement and maintenance of public order and combating terrorism. अपने लिए सरकार ने बहुत सारे इस डीपीडीपी एक्ट में प्रोविजंस बना रखे हैं टू बी आउट ऑफ द डेटा प्रोटेक्शन ऑब्लिगेशन. प्राइवेट सेक्टर को यहां तक का परमिशन दे दिया है कि हमारा और आपका पर्सनल डेटा वो बेच खाए अक्रॉस बॉर्डर्स, अलाउ है उसके लिए भी. लेकिन हम और आप अगर सरकार में हो रहे दुर्व्यवहार, कुशासन, इनका पर्दाफाश अगर करना चाहते हैं तो जानकारी नहीं मिलेगी. So this is the unfortunate impact that the Personal Data Protection Act is likely to have. जब वो implement होगा, किस तरह से होगा वो देखी जाएगी. But these are the fears that many of us have, and that's the reason why we all need to engage in these kinds of debates and discussions to see what is the ideal data protection standard and template that we need to have in this country. Does the DPDP Act fulfill it? Does it go in excess? or does it fall short? Unfortunately, in Parliament, because of the difficulties that existed during the business hours, opposition was out. There was nobody to oppose the DPDP Act when it was taken up for debate. Just like there was nobody to oppose the Right to Information Bill when it was taken up for debate in 2005. तब भी opposition ने walkout किया था और वो opposition आज सरकार में है. और उस वक्त वो सरकार में थे, उन लोगों ने इस बार walkout कर दिया. So बिना गहराई में जाकर डिबेट किए बिना और पार्लियामेंट्री स्टैंडिंग कमेटी को नाम के वास्ते खाना पूर्ति के लिए एक उनसे रिपोर्ट निकलवाकर ऑन डीपीडीपी बिल इस बिल को पास कर दिया गया है. द करंट वर्जन ऑफ द डीपीडीपी एक्ट इन बिल फॉर्म वाज नॉट इवन टेबल्ड बिफोर द पार्लियामेंट्री स्टैंडिंग कमेटी फॉर डिटेल्ड वेटिंग. उनको कुछ और जो 2022 में जो एक बिल्कुल बेयर बोन्स भी नहीं है, वो किसी कॉलेज स्टूडेंट ने ड्राफ्ट किया होगा उस बिल को, ड्राफ्ट बिल था वो. उसके ऊपर हम और आपसे उन्होंने हमारी राय मांगी और उस राय को उन्होंने किस तरह से जहन में लाए निर्णय लेने से पहले कि फाइनल वर्जन ऑफ द बिल में क्या क्या होना चाहिए बेस्ड ऑन पीपल्स इनपुट्स, वो हमें पता नहीं है. बट टुडे व्हाट वी हियर इज our commercial sector, business sector, etc., are very happy with the DPDP Act. Because it is, very forward-looking and very favorable to them. But this was a story when the bill was tabled in Parliament and it got passed. Today, what is happening? My absolute last point, and I'll stop now. Today, what they are saying is, oh my God, अभी हम गहराई में जा रहे हैं DPDP Act के requirement को लेकर. इतने सारे systems इसमें create करना है to collect, use, store and destroy information. तो हमें कम से कम 2 साल की तो मोहलत चाहिए इस कानून को इंप्लीमेंट करने के लिए. आज उस लेवल पे आ गए हैं. Especially the ones who use large data of you and I as consumers or as beneficiaries of some program or the other. So this is where we stand today. We have zero clarity about how our privacy is going to be protected in this country if that law will be made operational. Even I don't know, for example, that when I receive RTI replies from the government, am I required to black out the name of the PIO and the signature of the PIO before releasing the information out in the public domain? Because do I become a data fiduciary who has an obligation to keep whatever personal information that comes to my custody to keep it confidential? I have no clarity. So this is the state of affairs as far as the protection for personal data is concerned in our country, which is most unfortunate. I'll stop here. I'd like to thank Moneylife Foundation and all of you for giving me this opportunity to share my thoughts with you. Thank you.
Thank you so much, sir, for explaining the issue so well and in simple terms. We'll take some questions from the audience. If anybody has a question they want to ask, they can use the raise hands button that is available on Zoom. So I'll unmute you and you can directly ask your question. Otherwise, you can also post your question in the chat and I'll take it up directly. So there's a question that is not RTI related. Somebody had posted in chat. They had said, how can we look at data privacy issue when every day we get calls from robocallers, telemarketers for credit cards, personal loans, insurance issues and all that. So any comments from either?
Shailesh, do you want to go first?
I personally feel, look, private initiatives like this will continue. And like all amounts of laws are not going to work. Today, Google knows more about me than my wife does. So, to my mind, right to information is far more important for India at this stage. Comparing it to Europe and American countries and laws is not a fruitful exercise because there the penalty for doing wrong is fairly heavy and is strictly enforced. Our criminal justice system doesn't work like that. We have no way to curb corruption. Lokpal also is there doing nothing. And therefore, the Indian Act recognizes that there should be slightly greater access to information for citizens. If we close that, RTI disappears as far as a strong Citizen Empowering Act is concerned, as far as its ability to restrict corruption is concerned. But private people, there's no direct way of controlling, really speaking.
I have no answer to this question. Unfortunately, I don't know. because we don't know how all of this will roll out. Just today on my SMS I got कि नोएडा में प्लॉट इस सेक्टर में निकला है, आप इंटरेस्टेड है, अरे आपको कैसे मेरा नंबर मिला, ब्लॉक करता हूं, फिर कल आ जाता है. So how will this work? Will we be blocked from this? We have no idea. Uber ऐप खोलते हैं, ओला ऐप खोलते हैं, तो उनको पता चल जाता है कि हम कहाँ पे बैठे हैं. Now, will they be required to take our consent every time I open the app, saying that, okay, we've collected this information about you, that yesterday you went to this place, now do you want to go back to the same place again? Hugely problematic. We don't know how this is going to work. And even worse, is the centralizing nature of this law. अगर आपका किसी के साथ dispute है कि some telemarketer or something, has collected information about you without your consent, पूरे देश में एक जगह बैठा रहेगा डेटा प्रोटेक्शन बोर्ड, और ज्यादा से ज्यादा मे बी स्टेट कैपिटल्स में उनका ब्रांचेस बिठाए जा सकते हैं. दे विल बी कंप्लीटली आउट ऑफ योर रीच फॉर ग्रीवेंस एड्रेस. और वो सारे ग्रीवेंस एड्रेस भी अकॉर्डिंग टू द लॉ विल बी डन ओनली इलेक्ट्रॉनिकली. हमारे यहाँ सब कुछ डिजिटल करने का तो अभी ये क्या कहते हैं, ये लत लग गई है ना. एवरीथिंग हैज टू बी डिजिटल. कल को डिजिटल बच्चे भी पैदा हो जाएंगे. नथिंग इज टू बी डन इन एन एनालॉग और नॉन डिजिटल फैशन. एवरीथिंग इज डिजिटल. And because of it, cyber crimes are anyway going up, 10 times above what they were in previous levels. But I don't want to get into that. So this is where the huge problem is. How will we resolve these disputes? And the second part, arguably, to the best of my knowledge, ours is the only country which has provisions for imposing penalty on data principles like you and I in the data protection law. और किसी भी देश में जहां तक मुझे खबर है नहीं. अगर हमने गलती से भी अपने बारे में गलत जानकारी डेटा फाइड्यूशरी को अगर दे दिया, हमारे ऊपर 10,000 तक का जुर्माना हो सकता है, और किसी देश में नहीं. तो कौन सा डेटा प्रोटेक्शन की बात ये कर रहे हैं? ये तो डेटा पेनल्टी वाला कानून हो गया ये. The sad part is these kinds of provisions which many of us opposed simply did not get discussed either at the parliamentary standing committee level, because this bill was never presented before them, nor it got debated in the house because opposition had walked out. And today we are stuck with a law that is likely to create, cause more harm. This is where the problems are.
Right. Thank you, sir. There are no other RTI questions, but there's another privacy question that has been raised. Somebody is asking about the privacy policy on the internet website that you get when you visit websites. So there are times when the policy changes without the users being intimidated. Is there a technical solution that we can come up with? I know this is not RTI related, but if either of you can comment.
As far as I'm concerned, no comment.
Yeah, no, I think as far as the DPDP Act is concerned, those who collect surfer-related data on any website, they will have to conform with the DPDP Act. Privacy policy बनानी पड़ेगी. I happen to head up an NGO based in Delhi. Now we are wondering कि जो थोड़े बहुत हमारे पास जो डोनेशंस आएंगे लोगों के, स्मॉल डोनेशंस, उसके बारे में कितना इंफॉर्मेशन हमें कलेक्ट करना है. केवल कलेक्ट करके उसको एक हार्ड डिस्क में रखना काफी नहीं है, because the Data Protection Act has very stringent provisions relating to lapse of data protection security. लाखों करोड़ों तक का फाइन हो सकता है हमारे ऊपर अगर कहीं ना कहीं गलती से, लापरवाही से वो डेटा पब्लिक डोमेन में आ गया तो. सो देयर आर सीरियस चैलेंजेस. मैं ये नहीं कह रहा हूं कि डेटा शुड नॉट बी प्रोटेक्टेड, दैट्स नॉट द पॉइंट. द पॉइंट इज कि अगर कल को आप अगर कानून को इंप्लीमेंट करना शुरू कर दिए, जैसे डिमोनेटाइजेशन के साथ हुआ, जीएसटी के साथ हुआ, बिना तैयारी के, तो हाउ मच ऑफ litigation will this lead to? And I can say this with great respect and seeking the pardon of those of you who are lawyers, that this for us is like a citizens data fiduciaries nightmare as far as this law is concerned. But I think a lot of lawyers and advocates would love it for that very reason, कि इसमें litigation बहुत ज़्यादा बढ़ने वाला है.
Thank you, sir. I'm going to unmute CA Rakesh Gupta. He wants to ask a question.
Sure.
राकेश जी.
जी सर.
हाँ, go ahead.
कोई भी लॉ आर्टिकल 13 को ओवरराइड नहीं कर सकता. जो डिजिटल ये प्रोटेक्शन एक्ट है जिसमें सेक्शन उसने 81J को चेंज कर दिया है, एक तरह से वो ओवरराइड कर रहा है आर्टिकल 13 को, और वो वाइड एब्नेशियो है। जितने भी कानून हैं आर्टिकल 13 को वाइड वो नहीं कर सकते ओवरराइड। इसी बेसिस पे शैलेश जी ने केस किया है वर्चुअल हेयरिंग पे आर्टिकल 13 के लिए। मेरा दिल्ली हाई कोर्ट में अलाउ हो गया वर्चुअल हेयरिंग, और उसने सभी कोर्टों को डायरेक्ट कर दिया जो उसके नीचे हैं ट्रिब्यूनल्स को कि वर्चुअल हेयरिंग अलाउड है। कुछ दे रहे हैं, कुछ नहीं दे रहे। जैसे CIC वर्चुअल हेयरिंग नहीं दे रहा, पर उसे भी ऑर्डर है कि वर्चुअल हेयरिंग देनी है। आर्टिकल 13 है जो बेसिकली मैं इन्वोक कर रहा हूं, जिसके बेसिस पे मुझे काफी रिलीफ मिल रहे हैं। दिल्ली हाई कोर्ट में अब 45 जज हो गए हैं जो 33 के आसपास चलते थे, और जल्दी ही वो 60 पहुंच जाएंगे। जैसे जज ज्यादा होंगे तो पेडेंसी कम होगी। आर्टिकल 13 बेसिक है
आपको कोई
RTI के लिए
प्रश्न पूछना है?
कि आर्टिकल 13 को ही इन्वोक करना है यदि इसको डिलीट करवाना है। कमेंट है मेरा।
जहां तक वर्चुअल हियरिंग की बात है, महाराष्ट्र में गवर्नमेंट का GR निकला है कि सब जगह ऑल कॉन्स्टिट्यूशनल हियरिंग्स को वर्चुअली ऑप्शन देना चाहिए। दूसरा, मैं नहीं समझता हूं कि ये DPDP बिल को RTI एक्ट में अगर हम रिलीफ के लिए जाएंगे कोर्ट्स के पास तो मार खाएंगे, कत्ल हो जाएंगे। कोर्ट्स ने ऑलरेडी इसको अमेंड कर दिया है विदाउट बैकिंग ऑफ लॉ, और उसी को ये लीगलाइज कर रहा है। So my own submission is we should create public opinion, public discussion on this bill with respect to RTI, and then wait and see what happens.
बिल्कुल, मेरा संक्षिप्त में रिस्पॉन्स यही है राकेश जी, आपका पॉइंट बिल्कुल सही है आर्टिकल 13, लेकिन देखिए आर्टिकल 13 आमतौर पे कानूनों के बारे में है, लेकिन यहाँ पे लड़ाई दो कानूनें जो दो मौलिक अधिकारों को अमली जामा पहनाते हैं उनके बीच की लड़ाई है। तो प्रिंसिपल ऑफ इंटरप्रिटेशन विल नॉट सिंपली बी बेस्ड ऑन आर्टिकल 13, it will be based on balancing the two fundamental rights and whether that balance is achieved by the provisions of the RTI Act and the data protection law. So it will be at a much higher level of balancing than simply Article 13. Basis Article 13 मैं बिल्कुल मानता हूँ, but when these two laws give effect to fundamental rights, how are they to interact, how are they to engage, ये किसी एक किस्से में, एक केस में ये खत्म नहीं होने वाला है। This will be a long drawn battle. अलग अलग challenges आएंगे, अलग अलग तरीके के petitions आएंगे, and women's related information, children's related information, transgender related information, business related information, हमारे देश में, let me tell you, thankfully our Supreme Court has said that fundamental rights, particularly the fundamental freedoms, are available only for individuals. There have been several cases where business houses have claimed that we also are protected by these fundamental rights, and they have lost. Today my worry is, with the DPDP Act coming in, there is a small window that has been opened up for business houses to claim the protection of whatever is provided for various rights under Article 19 and Article 21. I'm suspecting that there might be there might be an expansion, क्योंकि अमेरिका में certain kinds of fundamental rights like freedom of speech and expression, including making political donations, उसी का एक हिस्सा है। Freedom of speech and expression का एक हिस्सा है right to make political donations. That right is recognized even for private companies. और आज की तारीख में तो कानून बदलकर फॉरेन लॉ फॉर्म्स को हमारे देश में भी दुकान खोलने के लिए अलाउ कर दिया. So all of that jurisprudence is now going to be brought in much bigger way than what our own law forms used to do earlier. So we are in for a much more and deeper and larger extent of litigation on these matters in the coming years. And that is where the worry is. जो सिंपल बातें थी, जस्टिस शाह कमेटी ने 2012 में बोला जो आरटीआई में जानकारी मिलती है उसको डीपीडीपी एक्ट के तहत वापस ना ले लिया जाए. जस्टिस BN श्रीकृष्णा कमीशन ने बोला कि मौजूदा 81J में थोड़ा और हार्म टेस्ट इंक्लूड कीजिए ताकि जानकारी प्राइवेट टाइप का खुलासे से अगर किसी को नुकसान पहुंचाता है तो वो जानकारी नहीं दी जाएगी, और नुकसान किस प्रकार के हैं उनका भी लिस्टिंग उन्होंने अपने बिल में दिया था. 2021 में जो डेटा प्रोटेक्शन बिल पार्लियामेंट में पेश हुआ और जॉइंट पार्लियामेंट्री कमेटी को जो रेफर हुआ, जॉइंट पार्लियामेंट्री कमेटी के रिपोर्ट में आरटीआई एक्ट को अमेंड करने के लिए कहीं पे रिकमेंडेशन नहीं है। तो ये किस मेधावी जीनियस ने सरकार में बैठकर आरटीआई एक्ट को अमेंड करने के लिए प्रावधान बनाया? जो ओरिजिनल बिल, जो ड्राफ्ट बिल 2022 में था, उसका एक फॉर्मुलेशन था और 2023 में जो पास हुआ उसका फॉर्मुलेशन बिल्कुल अलग निकला। बट अंतिम नतीजा वही है कि पर्सनल इंफॉर्मेशन विल become one category of information that by default will be and can be denied by PIOs in the first instance once this law becomes operational. That is a huge worry. वैसे भी सेंट्रल गवर्नमेंट का डेटा दिखाता है between 30 to 38%, 35 to 38% of the 12 to 14 lakh RTIs that come to central government every year, 35 to 38% of RTIs are rejected on the basis of 81J, which is personal protection, personal data protection. ये और भी बढ़ने वाला है, 50% तक भी शायद पहुंच सकता है, and that is a cause for worry.
Right. Thank you. We'll take one last question from the chat. Mr. Rajesh Bhatt is asking how RTI will help him find which of his digital data is available with the government of India and Maharashtra. Which data is shared and sold by the government, basically. Any comment?
I'm not sure I can answer that question.
नहीं मिलने वाला, मैं आपको बताऊंगा. The government has managed to put into the DPDP Act very clear provisions which says agencies involved in law enforcement, यानी पुलिस, enforcement directorate, CBI, फलाना डिमकाना, ये सारे organizations, इनको डेटा प्रोटेक्शन ऑब्लिगेशन से के दायरे से बाहर रखी जाएगी. ट्रैफिक पुलिस भी शायद बाहर की जा सकती. टेररिज्म के खिलाफ जो कार्रवाई करेगी सरकार, उसमें जो पर्सनल इंफॉर्मेशन कलेक्ट होंगे वो जानकारी पब्लिक नहीं की जाएगी, वो जानकारी डीपीडीपी एक्ट में आएगा ही नहीं. मतलब क्या है? अगर आप फिर डीपीडीपी एक्ट में दरख्वास्त देकर इन एजेंसी से पूछेंगे कृपया मुझे बताइए मेरे बारे में आपने क्या जानकारी एकत्रित किया है, देने की बाध्यता इस कानून में उनके ऊपर नहीं रहेगा. गवर्नमेंट हैज टू ओनली इशू अ नोटिफिकेशन सेइंग these 30 organizations are not covered by these particular provisions of the DPDP Act. वो फिट हो गया ऑलरेडी. क्या जानकारी पब्लिक करेंगे? मेनली ये जो सर्विसेज देते हैं ना सरकार, जैसे दिस स्कीम, दैट योजना, जो सरकार बोलती है रेवड़ी है लेकिन खुद उसको कर रही है, ऑपोजिशन करती है तो रेवड़ी स्कीम बोलते हैं, तो उनके बारे में जानकारी वो पब्लिक रहेगा, लोग पूछ भी सकते हैं. शायद स्कूल, हॉस्पिटल, कॉलेजेस, यूनिवर्सिटीज, इसके बारे में जानकारी हो सकता है, शायद हमें मिल सकता है, पब्लिक नहीं. जब मैं मांगूंगा शायद मुझे मिल सकता है. इनकम टैक्स डिपार्टमेंट से मिलेगा कि नहीं मेरे बारे में जानकारी जब मैं डीपीडीपी एक्ट में मांगूंगा? आई हैव नो गारंटी. उनको भी दायरे में के बाहर रखा जा सकता है लॉ एनफोर्समेंट के हिसाब से. So there is no clarity, and this has been one of the major criticisms of the DPDP bill and the DPDP Act by those who are experts on data privacy. They have said that how are you giving and why are you giving yourself such wide sweeping powers to remove entire departments and entities and organizations from the obligation of data protection? When I say data protection, not just safety and security, but also the obligation to tell people what information about them these departments are holding. वही obligation नहीं रहेगा. So the issues are far beyond and much larger than the attack on RTI. It is of course a very important part of it. But मैं तो यही कहूंगा, right to privacy actually आज DPDP Act के वजह से right to information privacy खतरे में ज्यादा दिख रही है, प्रोटेक्शन में नहीं.
Right. Thank you. We'll close out the session here, but before closing out, Mr. Gandhi, would you like to share some closing thoughts?
My only submission is we need to build a movement around this, and I'm concerned with RTI. And to me, if RTI is dead, a major citizen empowerment and democratic movement gets a major hit. And this is not being discussed in the nation because it's going in the garb of DPDP bill. If they had said they are amending the RTI Act, there may have been greater attention to this. Media and citizens need to discuss this. and try and protect their fundamental right. Thank you. Thanks to Akshay and thanks to Yogesh and to Venkatesh.
Thank you so much, both of you, for taking the time to speak and explain the issue in such simple terms. We have all enjoyed the session thoroughly and learned something new today. So thank you for taking the time. Thanks everyone for attending. Thank you and good night.